by the officer willfully and intentionally lying, that is a due process violation, and I suffer adverse collateral consequences behind that parole hearing.
Hi guys, it's Kathy. I hope you're doing well. That's what you're in for. That is what you're in for. Now we've seen Judge Cranky a lot lately with Mr. Kelly, but we forget that we've been watching Judge Cranky for way before Mr. Kelly came on the screen. And he has some bangers. Let me tell you, this guy is a banger. Pro se, habeas trial. He was convicted. He doesn't like the fact that he was convicted. So, of course, all of his rights have been violated. Now, this is just a 10-minute segment of the hearing that we saw during one of my live streams months ago, a year ago. I don't really remember. I'm going to leave the link in the description for the full hearing. But this guy he puts the pro in pro se. Here we go, guys. Enjoy.
That stated that there was no construction site in that area on that date and time, in which he testified willfully and intentionally that I was speeding through a construction site.
Did you have an opportunity to speak at your parole revocation hearing?
Yes, sir. I had the opportunity to speak at the parole revocation hearing, sir, but I would like to state something. By the officer willfully and intentionally lying, that is a due process violation, and I suffer adverse collateral consequences behind that parole hearing. And that is stated in ground 10 on my habeas pension. That's stated in ground 10. I suffer adverse collateral consequences behind that parole hearing. And he willfully intentionally made false statements, sir. Like,
I just suffered adverse collateral consequences from him. He owes me.
What else you want to ask? I'm trying to see where you're going at with, not no disrespect or nothing, but like, have nothing to defend on that behalf. Like, he was 100% innocent. You know, like, right is right and wrong is wrong. Point blank, period.
I had asked you whether or not you were given an opportunity to speak at your parole revocation. I was going to ask you, did you speak at your parole revocation hearing?
Yes, sir. I spoke at a parole revocation hearing.
And did you tell the hearing officer about the officer lying?
No, sir. He told the judge, he told the lawyers, he told the bailiff, he told the people sitting in the gallery, he told the other inmates. He told everybody.
Did I tell him about the officer lying?
Yes, sir.
Yes, sir. Yes, sir. I told him that. I just got the facts now, though. I just had the facts. Now I didn't have the facts then. I got all the facts now. The facts wasn't. I didn't have no facts then. I have all the facts now.
Were you paying your $90 supervision fee?
Was I paying it?
Yes, sir.
Hold up for a second, sir. Yes, I owed it $90, but that is a person can't get sent to prison for that. So you can't count that against me neither. And I also got that inside my ground. Just hold up and give me a little bit of time and I'll find it for you. Everything already documented in black and white. You got to give me a little time to find it. But even if I don't find it, it's in here, but it's still a violation of the Georgia Amendment and the Constitutional Amendment. But that alone, and what
you're violating the Georgia Amendment. You are violating the Georgia Amendment. Point blank, period.
Can't count anything because it's something called due process of law, sir. The rest, it what got me here. You know, so you can't skip and jump from this to this trying to find things, you know, so like it's a violation of due process of law, sir. Either way it goes. State-wise, Georgia state constitutional and United States constitutional, sir. Any more questions? Like, not trying to be funny or nothing, but like, I've been waiting for a long time for this. Like, right and wrong is wrong.
Mr.
Like,
Ingram, if you would be quiet and let Mr. Daniels ask you some questions, we could proceed in this matter, okay?
Yes, sir.
All right. Go ahead, Mr. Daniels.
Had you received a substance abuse assessment by a substance abuse counselor?
No, sir. And that right there is also a abuse of discretion. And the reason why I say that is because nowhere on record had I had any dirty urines. And also, my last thing dealing with drugs is over 10 years ago. So nowhere I shouldn't even have had like that on my record, because I'm not on probation for that. Like as far as like the conviction and everything, the FNL conviction, and also the two piss tests that I had pissed it for when I was free, I came back clean. So like through record, the last thing dealing with drugs with my name is over 10
Was an aider.
years ago. And I also asked you to speak to the head parole guy and stuff when I was first told about that class, but he wasn't at the office then. So I was gonna ask him, you know what I'm saying, speak with him about it
Point
and
blank
everything
period.
else, so he could look through the files and see that the last thing that I had dealing with drugs at the time then was like 8 years ago. Now it's 10. So there's no way that I even should know, like that was a wrongful judgment, even as awful a person in that class. You know, somebody else could have been like taking it and stuff like that and all, which is I would have took it. They would have offered it to me and stuff. But either way it go, like they didn't even offer it to me. Like I had no violation until I caught this charge. That just violated me in general. So like I would have ever caught the charge, whatever they would have came around with it and stuff, I would have took it. But it's funny, you know, trying to hold it against a person when actually I didn't need it anyway. Not saying that I would have denied it, but it don't, you know, like if a tire already got air in it, you know, like what, you know, certain stuff, common sense.
I have no further questions.
All right, do you have anything else you'd like to say, Mr. Ingram?
Yes, sir. I mean, like due to all the evidence and everything that was stated, I would like to ask the courts that I'm entitled to habeas release. Like it's clear as obvious.
It's clear as obvious.
Do you have any other evidence you'd like to present to the court?
No, sir.
All right, Mr. Daniels, do you have any evidence that you wish to present to the court on behalf of the warden?
Yes, Your Honor.
All right, and it is?
I have Respondent's Exhibit A, which is the revocation order and proceeding notes, as well as the Effingham County indictment in guilty plea paperwork.
Any objection to those being admitted into the record, Mr. Ingram?
You can repeat that again, sir?
Sure. It is the probation revocation order and notes, as well as the Effingham County Superior Court indictment, plea paperwork, and disposition.
Any objection?
Oh, yes, sir. I would like to raise objection. I mean, you just stated it, but I don't like the arrest is what triggered the violation.
Do you have a legal objection, Mr. Ingram?
Yes, sir. That is a legal objection. That's a violation of the 14th Amendment.
All right, the objection is overruled and Respondent's Exhibit A is admitted over objection. Anything else, Mr. Daniels?
No, Your Honor.
All right. Mr. Ingram, the way I handle argument, or anything in rebuttal, excuse me. Do you have any additional evidence, Mr. Ingram?
No, sir.
All right. Now then the evidence is closed in this matter.
So it does get worse. The evidence is closed, but then they can make arguments. And then they could have written arguments. And he has more violations of his rights. Because if a tire has air in it, right is right, wrong is wrong. Point blank, period. I'm almost thinking about making that a shirt. Court vibes. Either just point blank, period, or right is wrong, point blank, period. That seems like a lot to put on a shirt, though. I mean, it would be a lot for a tattoo, but maybe not a shirt. Point blank, period. So that's Judge Crawford. And we've seen him a bit lately. He's taken over more since Judge Reeves stopped streaming. But That's what I got for you today. I hope you enjoyed it, and I hope that you show up to some of my lives to see the craziness with the whole family that we saw in our chat today. Thanks for coming out, guys. I appreciate it. I'll see you again soon. Bye.